Fundamentally, Summit is a purpose-driven business, and we live in a country almost creating a perfect storm, where we have a sophisticated financial services industry and a financially ignorant mass market. And what that breeds is a vulnerability to abuse. And if you have no referee in the middle, you get abuse. And that's what's happened in South Africa. And Summit has taken upon itself that its objective and its purpose in life is to bring greater equality to this imbalance of power. It's certainly not our role, and it's not our desire to be fighting in courts on a regular basis. Litigation is hard, litigation is expensive, but in the absence of an effective regulator, we have no choice, if we want to live our purpose, but to take on these fights and to ensure that the courts bring some equity to this imbalance of power.
In August 2019, Summit partnered with the University of Stellenbosch Law Clinic to launch a groundbreaking application in the Cape Town High Court, requesting clarity on the correct interpretation of the so-called In Duplum rule, which limits the fees that can be charged to a consumer when judgment is taken against them in terms of the National Credit Act.
About 3 years ago, in 2016, Summit noticed that there were a number of consumers that had taken out small debts, relatively small microloans, anywhere between 300 Rand and 8,000 Rand, and the amounts that they were actually repaying in terms of the emoluments attachment orders were exorbitant. And it was obviously in a clear contravention in our minds to the wording of the National Credit Act. So the case is basically a declarator. We want clarity on the wording of Section 1035 of the National Credit Act, where we say that you can only ever recover double the principal debt outstanding at the date of default. So if you default an amount of 3,000 Rand, you could never collect more than 6,000 Rand from the consumer. Because what happens is the fees are not really the issue in terms of the credit agreement, the service fee, the initiation fee. What is exorbitant is the amount of fees that the attorneys are charging to collect on this debt. And we're hoping that 1035 can combat this.
On 13 December 2019, the Cape Town High Court handed down their judgment, confirming each point in Summit and the University of Stellenbosch Law Clinic's ambitious application. This was a game-changing outcome for consumers, as all fees, including legal fees, must now be kept at the In Duplum rate, and no legal fees can be charged to a consumer unless verified by the court's taxation master.
So essentially the outcome does not actually change any legislation. What it does is that it actually confirms the position as it's always been. Since 2007, this is the way the National Credit Act should have been interpreted, but it wasn't. In effect, the debt is capped. Credit providers and their collectors have just abused the system and have continued to collect costs unabated. And our collectors will not be able to do so anymore.
Almost every single emolument attachment order will be due a write-off or a refund since 2007, when the National Credit Act came into being. So from an employer's perspective, who are under pressure on salary bills and wage negotiations, it would mean more money in the pockets for their employees. Every single employer out there would have a case on the garnishee deductions that take place on their payroll to get it audited, identify where more than double judgment debt has been deducted, and then get a write-off or a refund for that employee. So it really does change the game, and it will also in future stop bad behavior or undesirable behavior of lenders and collectors collecting far more than is due and really creating harm to our society.